Welcome to Legal 123s with ByrdAdatto. Legal issues simplified through real client stories and real-world experiences. Creating simplicity in 3, 2, 1.
Welcome back to another episode of Legal 123s with ByrdAdatto. I'm your host, ByrdAdatto, with my co-host, Michael Byrd.
Thanks, Brad. As a business and healthcare law firm, we meet a lot of interesting people and learn their amazing stories. This season's theme is Hard Conversations. We will take real client stories and we'll, of course, scrub their names to protect confidentiality. And these stories will be built around confronting and having hard conversations. They don't all have great outcomes, but there are plenty of teachable moments.
Now, Michael, before we get in deep in today's hard conversation, back in your youth, did you ever do shots?
Well, anytime you reference my youth, I feel like something's coming because you like to reference my age often. Well, it might surprise you, Brad. I leveraged my typing skills in high school to actually become a Miller rep in college.
Oh.
So I guess they just saw the personality. It was kind of like the modern day influencer or prior day influencer.
Sure.
And but what was a good fit for me there is I was never much of a hard alcohol person.
Oh.
The problem is I like to drink the hard alcohol in the same way I like to drink beer back then.
Fast and
same
furious.
Pace, yes. And so but yes, I did do shots back then, but mostly was a beer person.
Okay.
How about you?
Yeah, I was never much of a shot person, probably similar for the reasons you said, but it seemed like all of my friends loved it. And between the Three Wise Men shot, which for those who don't know, it's Johnny Walker, Jack Daniels, and Jim Beam, the Three Wise Men, Johnny, Jack, and Jim, and Jägermeister, those seem to be placed in front of me often in my youth, and I just really never really liked them. I don't know, Michael, when was the last time you had a shot?
First of all, when you just said those names, I shuddered a little bit. So my memory's still strong. But actually, we just did an episode recently where I left a bunch of clothes in a hotel in Shreveport.
Yes.
That was the last time I've ever had a shot.
Well, there you go.
And that was Goldschlager.
Oh. Yeah.
Yeah. What about you?
I don't actually remember the very last time I had a shot, but on my 30th birthday, I basically had pledged that I would no longer ever take shots. And full disclosure, it was not because I did shots on my 30th. It was like, I'm done with them. And I'm not perfect on this pledge, as you just kind of alluded to. And I've done a really good job of trying to get really close to that until that Vegas moment that I referenced in a previous show of ours.
Where you bragged about winning?
Well, I mean, yes, it was winning.
Yes. Okay. I remember that. So where are we going with all this shot talk? I feel like we're taking a downward spiral on our podcast. We had Jay talking about gambling a few weeks ago. Now we're talking about shots. I really hope we're not having a little side conversation about meth labs next time.
Okay, yes, I'll try to be careful in the vice talk here. But last week, I read about this class action lawsuit in which this company, Sazerac, which makes and sells these miniature bottles of Fireball Cinema whiskey, and they were sued for
not being big enough.
No, actually, that was not it. But actually, they were sued as, unlike their big bottle cousins, the minis actually don't contain whiskey. It's just malt liquor. That's why apparently it tastes like Red Hots and not whiskey. Now, this is according, of course, to a friend of mine. Only the big bottles say whiskey on the label, but plaintiffs contend that the bottles have near identical graphics. And if you're at a convenience store shopping and you're not carrying your magnifying glass, it's really, really hard to tell the difference.
So I wonder if it even says that it's malt liquor, if it's in the fine print. I don't know.
Sounds like a complicated defense there, Michael. But
a lot of lawyer stuff.
Which is one of the reasons why you can actually buy Fireball Cinnamon whiskey at many gas stations and bodegas and convenience stores. These minis are entirely different. They're a cinnamon-flavored alcohol product, which is I always think it's funny when it's flavored. So it's actually malt beverage with natural whiskey and other flavors and caramel coloring, which makes it sound like a malt beverage with whiskey added. However, it merely references whiskey flavoring. So there's no whiskey, and it does not and that's one of the reasons why it doesn't have to be sold in liquor stores.
A couple things to say. Number one, I feel dumber for having had this conversation. And number two, what in the world are the damages for not getting the right kind of shot?
Apparently not more brain cells.
Out of a gas station.
But according to the lawsuit, those who consumed the miniature bottles of Fireball were deceived thinking they bought it for whiskey, and there was none in there. And Michael, I'm sure these plaintiffs in this case, they were looking for some great whiskey at a gas station, which burns like hell. Yes, Brad. I think we got to move on. I have a very vivid image of who these class action plaintiffs are. I'm guessing college kids that are not getting as much of a Fireball as they were expecting. Yes.
But is there some connection to this and today's story?
Maybe. We just might really need to push our limits to get there.
Talk about shot talk, I guess.
Maybe. It was just interesting. Well, I'll get into today's story, Michael, for our audience. And they might feel like they've heard this story before this season, as the elements of this is starting to feel like it's common, but it's different than the other stories we talked about already.
Okay, well, let's jump in.
All right. Today has to do with two orthopedic surgeons. They are best friends who graduated from fellowship together, and they decided to start their own orthopedic practice, and we'll call them Dr. Parker and Dr. Osborne.
I assume, knowing you, Brad, that this is some movie name or the names you've picked today. Yep,
and I will save the movie reference until we get further into the story.
Okay, well, just don't forget this time. A couple of times ago, you forgot to come back around when you promised something at the end.
I won't promise then.
Okay.
All right, Dr. Parker and Dr. Osborne decided that after fellowship, they didn't want to work for anyone else, and they wanted to form their own entity, even though they actually had great job offers from bigger shops. And so Dr. Osborne told Dr. Parker he would get with his attorney to form an entity, and they would own it 50-50. By the way, when he was saying attorney, he was actually referring to himself.
Oh, yeah. Nothing could go wrong here. This actually reminds me of when I played doctor and can turn a small cough into a rare disease with the help of my assistant, Nurse Google.
Yeah. Dr. Osborne went online, and he filed a certificate of formation with the Secretary of State, naming him as the manager of the professional limb liability company.
Okay, Brad, let's pause for a moment. We're going to unpack that sentence a little bit. So we have a little bit of vocab for today. First, for those who don't know, the certificate of formation, in some states it's called the Articles of Formation or Articles of Incorporation. This is the initial document you file with the state, and it's really the document that, from the state's perspective, makes you an official business entity. And so, second, when Dr. Osborne listed his name as manager, this somewhat goes back to a few episodes ago. We talked about different hats that people wear. A manager is kind of like in a corporation, a board of director, but that it is a decision-making role. And so you're saying Dr. Osborne listed himself as an initial manager, and so that gave him power to control the business.
All good points, Michael. And any additional comments on the fact that Dr. Osborne did all this online? If we want to, we can address that in the second half of the story.
Do I need to take a Fireball shot to prepare myself?
Well, not unless you really want to have that burning sensation. But back to our story. Well, like most startups, the first 12 months was pretty tough for the physicians. Besides trying to build up their patients, it can be overwhelming to run a business with administrative tasks for the day-to-day, like hiring and training them and getting good commercial insurance contracts and being staffed by all the right nearby hospitals. It's a lot.
Yeah, it's pretty common, and owning a small business is not for the faint of heart. You have to have a passion for it, for sure.
So Dr. Parker and Dr. Osborne also appear to have kind of different work beliefs. Dr. Parker was working really hard to help grow the business and see the patients, while Dr. Osborne was seeing patients, actually not even at the same volume, and he really wasn't interested in the admin side of the practice.
I'm starting to get that feeling, that ominous feeling, Brad, when you start setting things up like this. But, I will say this, it's kind of hard to own a business and avoid participating in the admin side.
Well, it gets more fun. So, to the surprise of Dr. Parker, about a year and a half into the practice, Dr. Osborne walked in one day and told him that he had accepted a job at the local hospital they're both on staff at, and he was going to start in 30 days.
Okay, well, that took a turn.
Yes. And as you can imagine, Dr. Parker was in shock, but he wished his friend well. And over the next 2 years, he really had to really dig deep into himself and really build up a decent orthopedic, really build up his practice. And he actually built a decent orthopedic practice by himself.
Okay, well, Brad, this season's about hard conversations. Did you skip that part of the story?
Well, Michael, as you're about to learn, this story will get stranger, and it can get stranger real quick. So Dr. Osborne's CPA called Dr. Parker out of the blue and asked, where was Dr. Osborne's K1 for the last 2 years since Dr. Osborne owned 50% of the orthopedic practice?
Well, first, there's another vocab word for today for our audience, a K1. This is a IRS filing, and you hear this commonly in business entities. And IRS has a lot of different forms that you'll file to your personal tax return. Schedule K1 is a federal tax document used to report income, losses, and dividends for a business or a financial entity's partners, or for an S corporation's shareholders. So, and then second, Brad, I thought you said Dr. Osborne left the practice. Why would his CPA ask for the K1?
Well, Dr. Osborne told his CPA that he was never bought out of the practice, and as such, he still owned 50%, and as such, he should be receiving 50% of the profits also.
Ooh. Okay, this is crazy, and I'm curious, Brad, why was the CPA reaching out to talk about this as opposed to Dr. Osborne himself?
Yeah, it's a great question, and as you can imagine from Dr. Osborne, this again felt like it was at a left field. They were good friends, and you would think that, as you said, it would seem like that would be the initial call. But so Dr. Parker, he called us and asked if we could help. I asked, right away for the corporate documents so that we could better understand the rights of all the parties. And this is the next major surprise happened when we received the documents. Now, as a reminder, Dr. Osborne filed the certificate of formation with the Secretary of State, naming Dr. Osborne as the sole manager of the professional liability company, and never listed Dr. Parker anywhere.
And let me reiterate, we just talked about this a moment ago, but this means that Dr. Osborne, according to the document with the state, was the person with the power. A manager is like that, like I said, like a board member in a corporation. And so he controlled this entity.
That's correct. And worse, Michael, besides Dr. Osborne's CPA obtaining the EIN from the IRS, the certificate of formation was the only corporate document that actually existed. So there are no other document that listed Dr. Parker even as an owner of the entity or even a person with control over the entity to make these decisions that Dr. Parker had been running for years at this point. And Dr. Osborne had also received advice now at this point that he should be bought out of this practice since he was still an owner of it. And actually, believe it or not, audience members, Dr. Osborne at this point was looking for a nice payday since the practice was doing so well.
Oh, man. Okay, well, you mentioned the IRS and the EIN. How is that relevant?
Well, great question, Michael. So good news is for Dr. Parker was that the CPA for the practice had been issuing K1s to the IRS since day one and noting that it was a 50-50 ownership. So the CPA basically, for audience to understand, is that it was telling the federal government that this is owned by two people, 50-50. And so it wasn't really a huge issue as to whether or not there was never a question in doubt whether or not Dr. Parker was an owner. It just nothing else existed.
There's just a question of why is he coming back 2 years later wanting his payday after he'd gone to go work for the hospital. But where was the hard conversation, Brad?
Well, there just never was one.
It sounds like they did not put their big boy ortho pants on to have the hard conversation on what would happen if one of them left the practice. They elected for the rose-colored glasses strategy, much like some of our other stories. And by the way, are you ready to tell us about the movie reference?
Yes. For those who haven't figured out, I'm referring to Peter Parker and Harry Osborn from the Spider-Man series.
Of course.
Two best friends who eventually became enemies, as Peter Parker is Spider-Man and his friend Harry Osborn became the Green Goblin. And much like today's story, Peter Parker was shocked that his best friend became his enemy and tried to destroy him.
I should have gotten the clue when I saw your Spider-Man action figure that you brought to the show today, but, I just thought you were playing on the side.
Well, Riley, just make sure that the Spider-Man's out of the image for our audience members.
Okay. Well, the lack of any hard conversation has put Dr. Parker in a terrible spot. Before you let us know, Brad, what happened with Dr. Parker and Dr. Osborne's relationship, let's go to break and then talk about some of the lessons to be learned from today's story and tell the audience what happened at the end with Dr. Parker and Dr. Osborne.
Many business owners use legal counsel as a last resort rather than as a proactive tool that can further their success. Why? For most, it's the fear of unknown legal costs. ByrdAdatto's Access Plus program makes it possible for you to get the ongoing legal assistance you need for one predictable monthly fee. That gives you unlimited phone and email access to the legal team, so you can receive feedback on legal concerns as they arise. Access Plus, a smarter, simpler way to access legal services. Find out more. Visit ByrdAdatto.com today.
Welcome back to Legal 123s with ByrdAdatto. I'm your host, ByrdAdatto, with my co-host, Michael Byrd. Now, Michael, this season our theme is hard conversations.
Well, let's reset a little bit as we start to dive in. So Dr. Parker and Dr. Osborne were buddies.
Yep.
Decided to start their own practice out of school. They utilized the rose-colored glasses strategy when they started. Mm-hmm. No hard conversations to be had. They just got up and running.
Yeah, no documentation to be had either.
And, surprise, surprise, it was hard. Hard, not for the faint of heart to start a business. And no slight on Dr. Osborne. He realized that this was not what he wanted for his career. He wanted to be an employed physician, wanted to not have to deal with the admin side of things. And so after a year and a half or so, Dr. Osborne suddenly says, I'm out of here. I'm going to go. I've got a job elsewhere, gives 30 days notice. The practice is hanging on by a thread still at this point. Mm-hmm. And so apparently they part ways and, they both start living their life. And Dr. Parker, lo and behold, starts building something of value. And Dr. Osborne reappears one day asking for his piece of the pie because he's still a 50-50 owner. And, there's a little back and forth about the lack of documentation that went on. But that's kind of where we left off, is that we're at this moment in time where this CPA enters the story as his agent and starts asking for or making demands, for his ownership stake.
Yeah. And, and Michael, let's pause because I know the second half, we definitely want to make sure our audience members think about some of the tools that they could have used. And we've referenced this in lots of other shows, but for those who are hearing for the very first time, we have an internal tool we use when helping develop governing documents, which we call the 4 C's, to assist our clients on focusing on really the important elements that will help develop a great plan. And for our audience members, could you remind them what are our 4 C's?
Yeah, and we've had several episodes this season built around hard conversations for each of the 4 C's. Mm-hmm. The first C is cost, and essentially that is, what are you putting into the business financially and what are you expecting out of it, both in terms of ownership interest, but also in terms of, expectations on revenue streams and return on investment type considerations. The second is compensation. When you're owners together, what is your compensation model going to look like? Third is control. How are decisions going to be made once you're owners together? And finally is contingencies. And this is the one that we're going to talk a little bit about today. But essentially, this is the prenup. If you got 2 people that are getting business married, this deals with the what ifs and what happens if somebody leaves, whether it's a bad breakup or just I can't stomach this and I want to go work at the hospital.
Yeah, absolutely. And Michael, today, as you said, we're really going to focus on the contingency element of the 4 C's tool. And it obviously had a big impact on today's story.
Yeah, and so when you think about contingencies, there's two different ways that you can build out a plan for dealing with the what ifs. And in a small business, when you have 2 owners or even, less than a handful of owners, it's often built around this idea that, if this event happens, then this sequence of things will happen so that we can unwind the relationship. And so it's, we'll define it as legally as a trigger event. And so if you decide that you want to leave, then, we have the right to buy you out, and here's the way we're going to determine the price, and here's the methodology for the payout, so on and so forth, when the payments are made. And then, as organizations get bigger with multiple owners, a lot of times that gets really complicated, and they'll move away, and you'll hear about kind of rights like rights of first refusal and tag-along rights and drag-along rights that are all built around, these contingency type situations that can happen, and making sure ultimately that you have a mechanism to deal with, a breakup, whether it's an actual, a bad breakup or someone's just leaving, or you're even, in some cases selling the business.
Yeah. And I'll add one more thing to that is that on those contingencies, a lot of times the contingencies is restrictive, meaning that even if you want to sell to someone else, especially these closely held entities, you can't. It's
right.
Not like a freely tradable asset that you can just turn around and sell to someone, because what if you want to leave? Then, and as you said, that's great, but it doesn't mean you can just sell it to anyone in the street. So in this case, a lot of times when we talk about these things where there's no corporate governance, there's no what if moments, there wasn't a prenup that you just talked about, so there's nothing in writing. So a lot of people want to go, well, I guess the state law. They must have had options that way. What do the states typically deal with on these type of issues?
Yeah, they're not very helpful. And so
that's it?
Well, and I can kind of correlate it to when we had an episode talking about control, and we talked about the ride or die decision making, which is like y'all either agree or you don't. Unfortunately, if you do nothing and you have no documents, you're defaulted into a ride or die situation, which does not work well when someone's already left and coming back saying, I still own this.
Right.
Because you don't have anything to fall back on. And the statutory laws are not great. I mean, really your choices are figure it out or dissolve the entity. And even that can be complicated if they don't both agree to dissolve the entity.
Yeah, you're spot on. And actually those were some of the conversations I started having with my client as we kind of walked through his options, which is, look, since we have nothing in writing, there's no state law I can point to and says this guy should have sold, or you had to discount it. And so that option one was to buy him out, either at the purchase price, what you talk about that he wanted, or some discounted purchase price, or just ignore it and see what happens and wait and see if he ends up suing you, or just dissolve the whole entity. And anyone listening to this who understands an orthopedic practice is not like aesthetic practice. When you dissolve that entity, you're losing a lot of different things, and one of the things you're losing is your EIN, and this has massive issues when dealing with commercial and federal payers, because all your payments are tied to your EIN. And so it's not as easy just to flip off the light switch and flip it back on by forming a new entity. Things have to happen, and so it's not an easy transition by any means. But, Michael, they didn't have that hard conversation up front. There was none whatsoever. What differences do you often see when you're advising clients, or when you do see it happen, when they discuss these what-if moments or these contingencies?
Yeah, I mean, and you have to just first acknowledge that nothing's perfect, because you're trying to plan today for what's going to happen if certain scenarios happen in the future, and we can't predict the future, so nothing is perfect.
Right.
Yet you put some structure into it, and you minimize the risk that things are going to blow up, and you have some paths to solving things when someone leaves. And sometimes when a partner is leaving the practice, you have to think through several things when you're looking at it into the future. One is that a source of revenue production is going out of the practice. So if you just say, okay, we're going to value the practice and we're going to pay you X, well, the practice might be writing a check to that doctor losing revenue stream to help cover overhead at the same time. And so you can inadvertently sink the business if you don't think about, at the front end, how do we protect the business? And one of the things that is commonly done is to say, okay, look, if you leave, doctor, we're going to value it at X, but if you're just leaving to go and, go take another job elsewhere, we're going to have a penalty to discount that purchase price so that the practice can still survive. And we may not, if we ask you to leave, maybe there's not a penalty, or if you retire, maybe there's not a penalty, or, unfortunately, if something like death or disability happens, they may be full price. But we want to think about ways to protect the business in case, one of the doctor leaves.
Yeah. And the thing that we often get questions about on that, Michael, is that they'll say something like, well, what if we change our mind? Well, the good news is if you put the prenup in place, you can always agree otherwise. If both parties are like, you know what, this makes no sense now that I'm leaving, why don't you just pay me $5 to leave instead of going? Parties can always amicably agree otherwise. You're putting these things in place because sometimes it's not amicable.
Right. Well, tell me about Dr. Parker.
Well, great segue into not amicable. So, Michael, since nothing was in writing, and as you noted earlier, there's no state law that we could point to that said he had to do this or had to do that, that really said that, if Dr. Osborne leaves the practice and goes work for the competitor, that this would trigger him from stop being an owner. So that didn't exist. And initially, Dr. Parker thought, well, they would just go the friendly route. And as Dr. Osborne, of course, was one of his best friends, so he tried to directly communicate. But Dr. Osborne just kept blowing him off and telling him just to speak with his CPA.
They'll tell it to the hand, huh?
Mm-hmm.
Well, that's not a great sign of a, quote, best friend.
Yeah, and then it got really ugly. Dr. Osborne was taking an aggressive stance that he wanted to be paid on the upside of the practice. If he was going to sell 50%, he started asking questions, on what distributions were being done and how much salary was Dr. Parker being paid, after Dr. Osborne left. And, Dr. Osborne really had this great delusion that there had to be some high multiple because he owned 50% of it.
Makes me wonder if he was reading about these orthopedic practice sales going to private equity.
Yeah, who knows? But, of course, all these demands were coming from Dr. Osborne's CPA. And, we were instructed that we could only negotiate with him on all related matters.
I'm curious, was this the same CPA who got the EIN?
Yeah, same guy. Well, look, this is where I'll kind of try to summarize it all. But after several calls and emails between us and Dr. Osborne's CPA, Dr. Parker agreed that he'd be happy to pay Dr. Osborne for a percentage of any funds that were collected by the practice after Dr. Osborne left, which were attributed to Dr. Osborne's actual services. But that was it. And eventually we were able to enlighten Dr. Osborne's CPA that the position they were taking would eventually lead to a lawsuit. And in this lawsuit, we'd point out that since Dr. Osborne was the sole manager of the practice, and according to the document that actually Dr. Osborne filed himself, Dr. Osborne is in breach of his fiduciary duty to the owners of the practice by working for a competitor and injuring the practice by leaving so abruptly, remember, just 30 days, and then soliciting the patients of the practice to move over to him.
This took a turn. Well, we spoke about fiduciary duties in another show, but as a reminder, it means that the manager has a duty of loyalty and care to the owners of the practice. So, to your point, Brad, when he decided to twist things and come back and stick his hands out to say, I'm still an owner, pay me, rightfully, you can say, well, if you are still here and still a fiduciary, you shouldn't be treating patients at the hospital.
Yeah. So, believe it or not, CPA was not aware that Dr. Osborne owed a fiduciary duty and the impact that this actually had in the court of law. And this helped lead the parties to some type of settlement. Now, neither party was happy with the results. As for Dr. Parker, this put a huge strain on him and it was emotionally straining. Spent a lot of conversations on that, and he spent a lot of time and money to help clean up this mess. But it allowed Dr. Parker eventually to own 100% of the practice, and Dr. Osborne gets some of the money out of the practice. But he was thinking hundreds and hundreds of $1,000s, and it was barely even close to tens of thousands of dollars, because again, it was tied to his production.
Well, Brad, this sounds like another one of your 550 rule moments that we've spoken about in other shows. You want to give a quick refresh on that?
Yeah, the 550 rule is pay someone up front $5 to do it correctly, or you're going to pay someone $50 at the back end to fix it. And that's obviously what happened here, ladies and gentlemen. But Michael, final thoughts.
Well, if you don't get your prenup in place, it's going to feel worse than a malt liquor fireball. That's all I have to say.
According to a friend. All right, audience members, next Wednesday, we have another story on hard conversation. And this one's going to be a little bit different because in this particular case, we're going to be having a story from the person who has to leave a medical practice and what hard conversations they had to have. Thanks again for joining us today. And remember, if you like this episode, please subscribe. Make sure to give us a 5-star rating and share with your friends.
You can also sign up for the ByrdAdatto newsletter by going to our website at ByrdAdatto.com.
ByrdAdatto is providing this podcast as a public service. This podcast is for educational purposes only. This podcast does not constitute legal advice, nor does it establish an attorney-client relationship. Reference to any specific product or entity does not constitute an endorsement or recommendation by ByrdAdatto. The views expressed by guests are their own, and their appearance on the program does not imply an endorsement of them or any entity they represent. Please consult with an attorney on your legal issues.